Welcome once again to the Labor Law Insider Podcast. This is your host, Tom Godar. I've been practicing law in the labor area north of 40 years. Hard for me to admit that, but all of this began back in May of 2021 when it was the premise of my colleagues and I at Husch Blackwell that elections have consequences. In the meantime, in those past 4 years, the Husch Blackwell family of labor lawyers has doubled. We've got incredible insider experience throughout our offices from coast to coast, and we've invited others from outside of Husch Blackwell to join us upon occasion as well. And so we are really excited to continue our Labor Law Insider podcast. And we promised you that it was a wild ride back in 2021. Well, folks, I just got off another call, read some more information on the internet, looked at a few more articles, and I promise you that we're in for another wild ride in the world of labor law. So buckle up and join us for the Labor Law Insider podcast. It is January 21st, 2025, the first day of the Trump administration, and I'm Tom Godar, your host of the Labor Law Insider. Welcome. It is wonderful to have you as we kick off our Labor Law Insiders for 2025. And there's lots to talk about, but we're going to start out with one of the most popular topics that we've seen. People liked it and moved it on to their friends. This was talking about what's happening to student athletes as employees on campus. We've talked about the Dartmouth basketball team trying to form a union, and we'll talk some more about that. But generally speaking, with the new administration, we might see some changes in which we're going to determine who's an employee, how they're going to unionize, if they have the right to unionize. And we've already seen huge changes with regard to name, image, and likeness, the opportunity for universities, and maybe the obligation for universities to pay athletes directly and lawsuits regarding that, and all sorts of really wonderful stuff. And also, this is the first day of the Trump administration, as I mentioned. And already we're seeing some of the changes, appointment and hiring freezes in the federal government and so forth. So that's taking place even as we speak. So by the time you hear this, maybe we'll know some more. But at the moment, for instance, President Trump has reappointed Mr. Kaplan, now Chairman Kaplan of the National Labor Relations Board, a role he had before the Biden administration took over. And that's just a harbinger of what's to come, I believe. But to join me on this wonderful presentation, I've got a couple of my partners and colleagues who have helped us walk through this whole notion of student-athlete employees in the past, and I'm really excited to welcome them again. First, we have Jason Montgomery, who practices basically university NCAA law, and he does this out of our Kansas City office, but his touches nationwide because the NCAA touches, hundreds of thousands, maybe millions of athletes and their families every year. Jason, welcome to the Labor Law Insider for 2025.
Thank you, Tom. Pleasure to join you and talk about these interesting developments in college sports and their interplay in labor law.
Well, it's great to have you here. And joining us as well is one of my favorite guests. He comes from California in the Oakland area, Tyler Paetko. Tyler has been practicing for a long time, recognized as is Jason by so many of his peers as best lawyers and all that kind of good stuff. He loves college athletics, especially the fact that the national champion from last night, the national champion, Ohio State, lost one of its two games to who'd they lose to, Tyler?
I believe that was Michigan, the rivalry game.
I believe. and Michigan's whole season was salvaged by that victory. And frankly, there were calls for the termination of this sort of world beater coach from Ohio State merely because he lost his, was it fourth game in a row, Tyler?
Fourth game to Michigan. Yeah, he's congratulations, Ohio. But as we talked about before, it will be forever tainted.
And I said it will be forever tainted in a group of alumni, which doesn't cover coast to coast. But welcome, Tyler. It's great to have you.
Thanks, Tom.
A couple of things that we wanted to kick off. First, as a personal story, I read today that President Trump has frozen all employment in the federal sector. Well, I'm old enough that I was going to join the federal sector as a lawyer in 1981 when another president on Inauguration Day, that was January 20, 1981, froze all federal employment. That was President Reagan. And that altered my life course perhaps forever. I never took that federal job. I jumped right into the private sector. And here I am now, 40 some years later, the host of the Labor Law Insider. Elections have consequences. So we're here right now, but why don't you tell us very briefly, and this is not really a show on what's going to take place because of the election of President Trump, but just give us 2 or 3 minutes, Tyler, on some of the things that we're going to see, and then we're going to tie some of that into student athletes as employees on campus.
Sure. So I'll start with the Dartmouth case that everybody's read about and been following for a while now. Dartmouth challenged a decision by an ALJ that these student athletes, the men's basketball team, could organize and form a union. They're essentially employees. And just recently, December 31st, 2024, the SEIU, which represents the men's basketball team, withdrew their petition for recognition. So practically what that means is we won't get a ruling by the full National Labor Relations Board as to the status of these student athletes and whether they are in fact employees and entitled to unionize. We still have some older law, including a Northwestern case that addresses that. And around the same time, there was a petition filed against USC, the Pac-12, and the NCAA as joint employers. And that petition has also been withdrawn. So in some ways, we have a blank slate now to write on. And in terms of what to expect in the future, I think we're all rolling out our crystal balls here. And I think a couple things that we're going to see more changes in leadership at the various agencies, including the NLRB. We heard about some yesterday, and I just read more to come. You're fired. So I think that some people in the NLRB, one of my favorite agencies, might be on the short list there. So what does that mean for employers? I feel like the last 4 years I've been in hibernation representing employers. Every ruling that came out, every advice memo, everything published by the NLRB was in favor of unions just across the board. And now we're seeing a little more life, a little more renewal of optimism among employer community. So joint employer is a big issue, captive audience speeches, Section 7 rights, and how far they expand. Recently, the NLRB, Jennifer Abruzzo, has been focused on restrictive covenants. I think that's on the agenda of the new Trump administration, stay or pay provisions, bonuses, and having employers requiring employees to pay those back. So there's a whole host of issues that I think we'll see changes, in the next year or two.
That's a great initial summary. Give me why would the SEIU withdraw from the role of representing the student athletes at Dartmouth, or why would the case get withdrawn or dismissed? What's the strategic reason that those who seem to be in the driver's seat would withdraw those cases?
Yeah, it's a good question. I mean, my conclusion or opinion is that they were worried about what the Trump administration was going to bring to the board in terms of new appointments, just overall philosophy on these cases. They could see the writing on the wall and wanted to not create a bad precedent, from the board, from the Trump board. So that's my read on it. I'm interested, Tom, what you think. But it was odd timing. I mean, literally Christmas Eve is when this was withdrawn. We're not interested in unionizing any longer. We're withdrawing our petition. End of story. End of case.
And they threw out some stuff about, well, there's now going to be NIL money and we don't need a union anymore because there's going to be some regulations and some of that. But yeah, I guess I'd be walking that same strategic line, is that, you don't want to create bad law if you think that by being patient for some years, you might get a more sympathetic tribunal. And you think that that sympathetic tribunal might be affected by maybe an election in 4 years from now. Interesting stuff, though, for sure, that these things that we were watching so carefully just get withdrawn. To try to miss a news cycle, maybe you take it out on December 24, so people aren't talking too much about it. That's interesting stuff. So what's going on in your world, Jason, to start discussion? We're seeing student athletes and how their role as employees is now maturing, since we've got payment to these student athletes in the form of payment for name, image, and likeness. We see more and more of them on commercials and boosting brands and so forth.
Yeah, it's really been a seismic shift since 2021 when the NCAA deregulated their rules to allow for third-party payments. under the heading of no good deed goes unpunished, when they deregulated, they then were sued again on antitrust claims in separate lawsuits that were consolidated, really requesting back damages for the years that the athletes prior to the deregulation were not allowed to receive compensation from third parties. And in addition to that, the plaintiffs' attorneys threw in the television contracts and the fact that the athletes weren't allowed to share in the proceeds from the revenue generated from television, in particular in football and men's basketball. So what happened last year, among many other things in college sports, was a proposed settlement of 3 consolidated antitrust cases. House, Hubbard, and Carter are the 3 cases. And the settlement would permit then prospectively for colleges and universities to pay athletes directly. Either they can pay them a direct revenue share benefit, or they can purchase their NIL directly from the athlete. And most schools are choosing to purchase, or at least contemplating purchasing the NIL from athletes. The settlement itself is set to be approved in April. There's numerous objections that have occurred. I think that the standard thought is that it will ultimately be approved, but that remains to be seen. But regardless, what likely will happen is a shift into direct payments of athletes from the colleges and universities. And right now, there's currently a cap set at $20.5 million.
Who set such a cap? Where does that come from?
So the way this was structured is that the NCAA and the 5 autonomy conferences was now there's just 4. The Pac-12 went away, but they're still part of this lawsuit. So they're still decided to grab the bull by the horns, and they don't have a union to collectively bargain with. So we're going to create a structure within which we are able to manage this operation through an injunctive settlement agreement with the plaintiffs' attorneys for this class of student athletes. And by doing so, they are attempting to have some sort of stability in this marketplace for at least a period of 10 years. So the cap is set through that arrangement. The cap will go up periodically, and it's basically the average revenue generated by the autonomy conferences plus Notre Dame.
You know, sometime we might put this podcast where we can actually watch each other live. I mean, I can see you. You can see me smiling, thinking, where did $20.5 million come from? Which universities can affect it? I'm just smiling to think of which deeply pocketed alumni are sending those checks out. Didn't I hear about such a check going to, by the way, Michigan from one of our friends in, like you, California, actually kind of in your neighborhood, Tyler, to make sure that they had enough NIL money to go around.
I did see that. Yeah, it's a new world. And I mean, just my personal opinion, I'm not a fan of making a little semi-pro league now. That's essentially what we have. But that's the world we're living in. And I think there's a lot of, as Jason just pointed out, unanswered issues and questions. And my own view is that I don't normally advocate for legislative action. Usually it makes things worse for everyone. But here, I think we need comprehensive federal legislation to address NIL, unionization, whether student athletes are employees. And without that, we're going to have 2 decades, if not more, of contentious litigation, expensive, time-consuming. I'm a fan of college sports in general and college football, of course. And I think it would be bad for the athletes to have this just morph into just never-ending litigation.
Yeah, that's fascinating. There are those who accuse people like you, Tyler, and me, who are engaged in litigation of always being in favor of whatever sort of disputive world there is out there because we might get our piece of it. But it is confusing. And I go back to this balance. Is there some sort of a solution that comes because of NIL money and agreements in a lawsuit that settle it that makes unions irrelevant? Or does this, Tyler, suggest even more so that these student athletes are indeed employees because a certain amount of money for a certain amount of performance, and gives even greater opportunity for those who want to make the argument that they should be subject to the National Labor Relations Act as employees and the universities as employers?
Yeah, I think the jury's still out on that. I read the new proposed terms of the House settlement, and there are questions, that I don't know if the parties can just say they're not employees. See, it's in our agreement. labels are not always determinative. And so I wonder about that. I mean, I went back and read the Northwestern case. There's a January 2021 guidance memorandum by Ms. Abruzzo, and it's very, if you go back and read it, it's very detailed in terms of especially the amount of control exercised by these universities towards D1 athletes, everything from practice schedules to training tables and study time, film room. It's very detailed. And if it walks like a duck and talks like a duck, at least Ms. Abruzzo says it's a duck. It's an employee.
Well, I'm sure you're going to swear off having agreed with all of that analysis, but that's what the analysis suggested. Going back to you a little bit, Jason, tell us a little bit more about what this settlement might mean in the long run. Will it affect only D1 athletes? Will it affect athletes at all universities? Or is this a relatively limited set, though a large set, of the Power Four conferences? Tell us a little bit more about the impact.
So it can apply to all Division I athletes. Really, the class are Division I athletes in the Power Four conferences, the Autonomy Four conferences, and men's basketball and women's basketball athletes, and all Division I. But the terms of the settlement allow for other institutions that were not in those conferences or named as parties to opt into the settlement and be bound by the terms of the settlement, which ultimately how this NIL structure, as they're contemplating it, and salary cap, so to speak, or quasi salary cap, will be operated is at the discretion of the conferences that are making the settlement and the NCAA. But really, the conferences are driving the bus here. I think to Tyler's point, I've made this comment several times. The last great bipartisan issue, is everyone can agree we hate the NCAA. Ohio State had Tattoo Gate. Michigan had Harbaugh Gate. They all both hated the NCAA equally in that time period. And so what has happened is you also, in addition to this settlement, you have a patchwork of legislation in different states that try to individually address NIL opportunities for athletes in those states that still hasn't been, fully vetted in terms of this particular settlement or how, those rules might affect this settlement. I think the reality is those rules were put in place to be permissive and to allow for opportunities for athletes in the state and promote that individual college or institution within that state. So the thought is that they'll be amended to address this. But the bottom line is the Autonomy 4 has kind of stuck a flag in the ground and said, we operate differently than other Division I schools. We are not, St. Joseph's. We are not a smaller, we have large businesses, and we need to try to manage those in a sustainable way. What they still don't want to do is call their athletes employees, and they don't want them to have the full range of benefits, either that would come with NLRA or with an FLSA situation, which is a separate issue that's currently being litigated, I think, in the Third Circuit.
I mean, Jason, out of that comes this concern that there will be, or has already begun to be, a patchwork of responses to student athletes as potential employees. If the NLRB says we don't have jurisdiction over these folks because they're not employees under our definition, mightn't states step in? And if the NLRB says we don't have jurisdiction over public sector employees, mightn't, again, the state just step in with its own set of responses for these student athletes who, at least according to some, look a lot like employees?
Yeah, I think that's absolutely the case, and that's what we've seen happen with this, name, image, and likeness legislation in different states tailored to that particular state school. And what the NCAA and these other conferences are trying to do is to manage this national issue through this settlement agreement, right? So this is their last attempt to maintain some control and order over this by saying, we've all agreed to this. We're all agreeing to this arbitration. We're going to change the rules, and we're going to work collectively to address whatever legislative issues we have to on a state-by-state basis. And in fact, in part of the agreement suggests that the plaintiff's attorneys will assist in lobbying Congress for more comprehensive legislation that will address some long-term antitrust issues that NCAA rules could create.
All right, here's your quiz, Tyler. When's the last time Congress passed any labor legislation?
Labor, traditional labor, I'm going to say like 1947, Taft-Hartley.
Well, we can argue together as to what was labor legislation, but the truth is nothing comprehensive has been passed since before any of us were born. And whether it was the PRO Act, which has been sort of bouncing along for 5 or 6 years or something else. So I guess I'm not going to hold my breath, but I certainly understand where comprehensive legislation would be helpful, especially since right now there are a number of voices suggesting whether it's the Dartmouth basketball team or name any other, or name, image, and likeness, and the opportunities for athletes to receive compensation from admittedly very large businesses, which happen to be housed within university athletic departments. But there's a lot of people who want to throw their own sort of piece into this. I think, Jason, you were mentioning just in the last couple of days as a last gasp effort from the Biden administration, the Department of Justice was saying we're going to object to some of the proposed settlement. Tell us about some of those objections that are being raised right now.
Yeah, and there's been other groups that have objected. The two big pieces of this, just so we're understanding the context of this, is it's a $2.8 billion settlement of damages. And that damages is going to be distributed primarily to men in football and men's basketball. So 75% of the money is going to football, 15% is going to men's basketball, 5% to women's basketball, 5% to others. So that represents, to a large extent, how the revenue has gone from the television contracts. Now, in response to that, just on Thursday, as a matter of fact, OCR for the first time commented on the Department of Education Office of Civil Rights, commented on the application of Title IX to NIL and suggested that this type of additional benefits, compensation, whatever you want to call it, in a direct NIL should be provided proportionately to men and women under Title IX. Questionable whether that is, solely, fully accurate. There's certainly arguments for or against that as part of the higher education process and whether Title IX applies in that way. But they issued this, guidance opinion, which really is a document that doesn't have any necessary rulemaking or legal authority behind it, but is a position of an agency that could enforce the rule. So that happened. And then the DOJ on Friday suggested that the judge should evaluate whether she should permit an injunctive settlement agreement for 10 years that would provide an artificial cap on NIL payments to athletes, and that doing so would create additional antitrust concerns from the DOJ's perspective. So those are among two of probably the more significant developments in terms of objections and the back and forth that have occurred in this case. And it'll be interesting to see how the judge addresses that particular question and whether there is further comment or withdrawal from the Trump administration in terms of their position on either of these topics.
Jason, that helps us get a little bit of clarity as to how the evolving issues are affecting student athletes. But in terms of labor issues, this is more than student athletes that are being affected. Tyler, aren't the graduate students and other students on campus also looking at the possibility of being identified as employees under the National Labor Relations Act?
Yeah, that's correct. Just recently, a group of graduate students at Vanderbilt University withdrew their petition as well, but that's still a live issue. There's ongoing efforts to organize teaching assistants and graduate students who are also teaching.
Well, I think that the caution from us is keep your eyes open. We're going to see changes. It's obviously interesting for those of us who are watching to see that Donald Trump announced a firing of really important individuals in a public note on his X. I guess this one was on X that I'm looking at. So I don't recommend that you employers do that, to announce your firings publicly on X and then tell the employees down the line that that's what you've done. But the Trump administration will indeed continue to take some steps that will make our world interesting. Gentlemen, thank you so much for joining us on the Labor Law Insider. Any final thoughts? I'll let you go first, Tyler.
Yeah, I think stay tuned, especially in the next 2 weeks, not just with the NLRB, EEOC, DOJ. A lot of these agencies are already under fire. We know about the Loper Bright decision overturning or calling into question a lot of administrative decisions that were not properly vetted, not subject to public comment. So I think we're in store for some massive changes, just here in the next month. So stay tuned.
And what should we look for on university and college campuses in the next months and years, Jason?
Well, I will say that it does appear to me that Donald Trump is interested in college athletics and has been to many events, the Army-Navy game. He went to, I think, an Alabama football game. I think that he will be paying attention to what's going on in college athletics. And if he can take a win, so to speak, for assisting in any way with resolution and maintaining some level of the traditional college athlete environment, that might be something that occurs. His intervention is something that could happen, and it could happen publicly.
Well, thoughts and things to watch for, fellas. I appreciate it so much. Enjoy the rest of your inauguration one day after, and we'll be back at you soon for more discussion on the Labor Law Insider. Thank you for joining us, our guests, our listeners. Please, if you enjoy the Labor Law Insider, share it with your friends, like it, and we'll be talking to you soon. Thanks again for joining us on the Labor Law Insider.